Good afternoon, everyone. I see some people are still coming in, but we have limited time, so I'm just going to get started. My name is Kenita Williams, and I'm the chair of the American Bar Association's Construction Law Forum's Toolbox Talk series. Basically, it's a series we put on every 6 to 8 weeks where we have experts in the field, either consultants or attorneys, present on specific issues related to construction law litigation. Today is going to be a really interesting topic. We have Steve Swart of Rand Construction Corporation and Julian Ackert of iDiscovery Solutions. And they're going to be discussing Rule 26F conferences, how to prepare to meet with opposing counsel and round up your data, and how you can use a data specialist to help you to prepare. Without further ado, Steve and Julian, please introduce yourselves and help us learn more about how we can be better prepared for these sessions.
Thank you very much for that introduction. I'm Steve Swart. I'm corporate counsel at Rand Construction Corporation. I practiced law in private practice for about 14 years and moved in-house within the last 6 months or so. So I'm still learning the inside of the ropes, but I spent a lot of my time in litigation and specifically e-discovery issues. And so I'm pleased to be here to talk about hopefully getting your hands around the data at an early time and cutting down costs. And I'll pass it over to Julian.
Thank you, Steve. Hi, everybody. Julian Ackert here. I'm a managing director with iDiscovery Solutions. I am a technologist, not an attorney. So I come and support teams like Steve and other lawyers with a really deep dive into the data and the sources and how you get them and what you do with them. I'm a testifying expert, so much of what I do, I will stand behind and testify on as well.
Right. So we are here to discuss Rule 26F conferences specifically, but in connection with that, understanding what data are out there and how you get your hands around them. And by doing that, having a more productive Rule 26F conference and hopefully limiting discovery costs. So here's an overview of where we're going to be. We're going to look first at what the Rule 26F conference is. We're going to go to the 5 sort of essential steps for all counsel to take with regard to electronically stored information. We're going to move into mapping and understanding data sources and discuss some of the emerging data sources and considerations regarding finding them, collecting them, producing them, and putting it all together for a Rule 26F conference. So we'll move into first, Rule 26F conference, a possibility, not a problem. And why do I say that? Well, it's an opportunity at the outset of the case to discuss with opposing counsel and to present to the court issues about e-discovery. So you get together with opposing counsel, discuss data sources and things like that. And here we have, why does it matter? What everybody wants to know. Why do I care? And to me, it really is the first chance to avoid the data deluge. And that's in quotes because that's what Justice Breyer called it in 2007 at a Georgetown Law Symposium, dealing with the data deluge back. Goodness, that's almost 20 years ago already. So if it was raining then, it's pouring now. So Julian.
It's amazing how much I call it data exhaust, which is how much data an individual or an employee of a corporation puts out that is under the possession, custody, and control of the company, as well as how much of the data that is with a company sits out there today. It's exponentially growing, and data has a direct effect to cost. So if you can start to avoid and think strategically about data, because even though there's a direct effect to cost, There's also a direct effect into using data at your advantage. So it's a balance point. And so I love that Steve was talking about data deluge here, because I think that's really the key of using 26F strategically.
Yeah, and I have highlighted here rules 11, 16B, 26G, and 37E and F, and hopefully you never see that in a motion filed against you. But those are various sanction rules for making representations or not complying with obligations. So the basics of a Rule 26F conference. Who? Counsel must participate. You also may have your consultants or even your client representatives participate in the conference if they're prepared well enough to fill in any gaps that you might have. But like any client communications during litigation, you want to make sure your client's prepared. So you don't just sort of go all into this meeting. What the parties must discuss the nature and basis of their claims and defenses, make or arrange for the mandatory disclosures, Rule 26A1, discuss issues about preserving discoverable information, including electronically stored information, and develop a proposed discovery plan. This conference among counsel has to occur at least 21 days before a scheduling conference or a scheduling order is due under Rule 16B. This is, in my experience, amended and shortened, particularly in the Eastern District of Virginia. But the purpose is to foster cooperation and transparency, avoid disputes regarding ESI, and that's from the Federal Rules of Civil Procedure Advisory Committee's note to the 2006 amendment. So really, this is not about can I hide an ace up my sleeve, but how do we avoid the e-discovery tail wagging the litigation dog? It's better to put your cards on the table at the beginning. If something's going to be expensive and find out about a dispute before it happens, then be facing a motion to compel and potential sanctions later. So issues regarding ESI. If you haven't or aren't familiar with them, the Sedona Conference publications are almost essential reading for any practitioners doing anything with ESI. Judges cite them all of the time. And so this is from the Best Practices, the 3rd edition that came out in 2018. So some things that parties may address at the 26F conference: the scope of relevance, identifying data sources subject to preservation and discovery, relevant date ranges, how far back are we going to search, identities of individuals likely to have discoverable information. These are your custodians. So identify who might have that discoverable information. What forms should data be preserved in, and in which form should they be produced? Are PDFs okay? Do we need natives like Excel files? Is metadata going to be important? Identifying data sources that are not reasonably accessible. So what's disproportionate to the needs of the case, considering the claims and costs involved? Potential use of search technology or other methods of culling data to be reviewed and produced. Are we going to agree to search terms? Are we going to agree to exclude certain search terms? Are we going to agree to technology-assisted review? And then clawback agreements. What happens if you inadvertently produce a privileged document? So again, ultimately, why does it matter? First, preservation. Make sure you're not inadvertently missing something that is going to be material, non-duplicative, and relevant. So you know to preserve it at the outset. Second, sources to search, how to search them and how to review them. And to identify, again, sources that are inaccessible. Can you reach agreement saying we're not going to, it used to be we're not going to restore backup tapes, but Are there outdated computer programs that no longer operate to process certain data? Is that data accessible somewhere else? The
And
other
Steve,
thing,
that's a key point right there, is the inaccessibility, because that also is a direct and proportionate relation to the cost and value of the case. So being able to articulate inaccessibility and why you're not going there in the value and proportionality of the case is very important.
yes, and I'll piggyback off of what Julian just said, because ultimately this gets put into a discovery plan or a scheduling conference report that is filed with the court and forms part of the scheduling order in the case. If you are going to make a representation to the court that something is inaccessible, it should be backed up by facts and data to support your position. And that's where somebody like Julian can really, really help you understand the cost and complexity of getting the data in a form that it can be used versus its likely relevance to the case. The other thing, RFPs are not considered served until the counsel holds the Rule 26F conference. So you got to participate, because otherwise your RFPs are not considered served until that happens. I really, really, really like this, because when you submit to the court the 26F report, it forms part of the pretrial scheduling order. And that scheduling order allows the court to modify the timing, extent of discovery, and requirements for identifying, preserving, and producing ESI. So counsel can proactively head off concerns about, you always hear about spoliation and inadvertently missing a data source. If you're in agreement on what that universe looks like, maybe you can phase discovery, but we'll get into that. It really acts as a sort of shield, if you will, to protect against later spoliation and non-production concerns. Some helpful resources I've embedded in the PowerPoints. A lot of federal courts are now coming out not only with their own sort of local rules, but their own ESI guidelines and pretrial scheduling order supplements governing the search and production of ESI. So in whatever jurisdiction you're practicing, make sure you know the court's local rules, but also look at those protocols as a starting point, even if you're not in those jurisdictions, and consider if they make sense in your case. It's not a copy and paste, but consider, should we vary this? And if so, why?
Yeah, and Steve, that's a good point, because some of those jurisdictions are at the forefront of these ESI issues, and that's why they've got these helpful information pieces published.
So here's an interesting, this case here, DR Distributors versus 21st Century Smoking Inc., is a, as you can probably see from the pin sites, approximately 150 page iDiscovery opinion, where I think counsel ultimately was hit with $2.5 million worth of sanctions for failing to understand the difference between server and web-based email communications and the availability of messaging apps. That was a cautionary tale, but it says by 2006, it was generally understood that attorneys could not get away with, I don't understand these computers anymore. So you've got to know what's out there. So when it comes to ESI, 5 essential duties. Identification. You need to have a meeting with custodian interviews and potentially have data maps from your client. See if they know, if they can diagram out for you where data is stored and what applications are stored there. Preservation. This is where your litigation hold comes in. Then collection, review, and production. So remember, identify, preserve, collect, review, produce. As the prior slide said, the same basic discovery principles that worked for the Flintstones still worked for the Jetsons. You've always had to identify, preserve, collect, review, and produce. So step one, identification, custodian interviews, some key elements. And Julian, when you come in and you're assisting with understanding, helping counsel understand what's discovery going to look like, how do you conduct custodian interviews? Whom do you interview? And, what types of questions do you ask?
It's a great question, Steve. The reality is that I've had so many interviews with the custodian themselves who, when you ask them questions about, well, where is that stored? And, frankly, they say things like, well, it's on my computer. And unfortunately, that's not quite detailed enough for a technologist like myself to get in and find and collect and preserve the potentially relevant data. So really, these types of custodian interviews almost become a working session between counsel, the custodian, and IT, because the IT team for the client can tell you when he or she, the custodian, says it's on my computer, what they mean is it's in the Microsoft Office 365 OneDrive, for example. That gives me, as the technologist, enough information to go figure that out. Now, you can still have your custodian interviews and then come and present the information to your collection team, and we'll go and try to figure it out. But oftentimes it's more helpful to have everybody at the table at once during these custodian interviews, because it just gets to the information faster. The most important piece of the puzzle is having somebody from IT during those custodian interviews so that you can understand the systems where the data actually resides.
Excellent. Yeah, I think it's sort of, drawing an analogy to maybe a construction delay case. You're not just going to ask the project manager, but you're going to look at contemporaneous scheduling records and other project records to try to map out, okay, when you say delay, what do you actually mean, and where's the backup for that? So it's as you said, Julian, it's sort of an iterative process. It's not a one and done, and it's not just the person with most knowledge about the project, but it's IT, it may be HR, it may be accounting. The days are sort of over when you can just go to the project manager and say, okay, where are the relevant documents?
Mm-hmm. That's right.
So as we move forward, preserve and collection. And so again, these are just some, why is it important? How should you handle preservation obligations? How can somebody like Julian help you as an attorney or help a client collect data that may reside elsewhere? And what should your focus be in preservation and collection? So I think in that.
And let me tack on to there, because I think it's important, because we combine the two, preserve and collect. And there's really two ways to do this. There is preserve in place, and then there is preservation by collection. And depending on the system that you're dealing with and the sophistication of that system with iDiscovery capabilities, you need to make sure you understand which is the right protocol I need to take. So for example, many clients are on Microsoft Office 365. Well, within Office 365, you can flip a switch saying preserve employee ABC's data. And that is a preserve in place. And therefore, you don't have to spend the dollars on collection at this time. Or alternatively, you could draw your rings around your custodians and say, well, we've got a few key custodians, but we've got a broader set here. Let me just preserve the broader set by preserve in place. It's not a huge cost effort, because you don't actually have to collect at the time of preservation. But that's something that's a nuance you really need to understand about your client's systems and data. There are many systems where you can't preserve in place, and therefore you have to preserve by collection. So that's one thing to really think about as you're going through preservation and collection.
Yeah, that's great advice. Not just email anymore. It used to be, all right, give me your emails. Let me see your file structure for your Word and PDF documents. Those days are long gone. So you can
Yes.
see some examples here, but I'm going to let Julian sort of walk
Yeah.
through what are the data sources, where are they located, that lawyers, especially construction lawyers, where so much can occur informally and so much can occur on specialized platforms, this becomes crucial.
Absolutely. So remember, I was talking about the amount of data exhaust that an individual has. That's because we're completely connected to a wireless and data-centric world in today's world. In addition to email, you may have, for example, for those of you who need change orders that are only stored on text messages on phones. I've definitely dealt with construction cases where that's where your change orders are stored. Or alternatively, you may be dealing with a more sophisticated client who's got Primavera or Procore, and the change order system or the information is stored more centrally inside those systems. So when you look at, what is my scope of potentially relevant data, you need to think beyond email. You need to think, how do people communicate on a day-to-day basis? I'll tell you, the biggest source of data that we see right now, in addition to email, is chat messaging. A lot of teams are using chat systems like WhatsApp to do group communications, or even them messaging on their phone. And it becomes a little messier and stickier because those phones might be BYOD, but it's potentially relevant data sources that either you need to account for or you need to think opposing is going to be asking questions for. I'm working a construction case right now where our side did a very good job of going to mobile devices and getting data. And we spent the dollars to do it because we are now in an argument with the other side because they produced almost nothing in text messages. And what they did produce was wholly inadequate from a scope and volume perspective as far as getting relevant information. But because we did it right, we've got a much better leg to stand on in front of the court for that. So this slide, and I'm sure these slides are available afterwards. We talked about that with Kenita and team. These are the different types of sources that you really need to think about.
I think it comes up to the next point, which is, okay, I know where the data are. I know what the map looks like. How do I search the data that I know for potentially relevant or responsive materials? Because again, it's not keyword searching emails necessarily. It's not keyword searching documents. We now have drone footage, modeling things, scheduling software, customized tools. So Julian, can you help us understand what considerations should be entering into the calculus as to you mentioned the separate preservation, and now we're talking about collecting and potential review and production.
Absolutely. So historically, the just traditional vocabulary I hear from counsel is, well, just go image the devices. And the reality is, we live in a world where the user experience of our devices means that everything is synchronized. So what I see on my iPhone is the same as what I see on my tablet, is the same as what I see on my laptop. And because of that, our devices are endpoints, and there really is a mothership that has all of the data that synchronizes down to the devices. We call it the hub and spoke mentality. If you think about a company's and your client's data that way, you want to go collect from the hub because that's a centralized location. And if I collect from the hub, I don't need to go to everybody's phone and everybody's laptop and everything like that. If the hub and scope, if IT says the hub contains everything that would be on the endpoints. So that's one thing to consider is, where am I going to go collect for the least amount of money, where I'm going to get the most comprehensive set of data. And then you want to think about the data sources that are the spokes or the endpoints, if you will, and what's unique to those data sources. Remember, we don't have to preserve duplicative information over and over again, but if there's unique information on those data sources, you're going to need to target collect that information. There's a lot of tools and systems out there to help, especially with Office 365 and Google Workspace, which I think between the two of them, you're going to see probably 90% of companies using these types of systems, these cloud-based systems. But the most important thing to also remember is, what am I doing with it after I collect? So in some instances, we've seen collection of emails in PDF format. And that doesn't work very well because now I can't mine that information and run searches against who sent communications to whom during what date ranges. I have a problem because I've collected in a certain way, but I'm not thinking about search and production. So collection has to think about, what am I going to do with this search and review, and how am I going to present to the other side, production?
Yeah, and that is all something, again, that once you understand where your data are, what is potentially out there, what is duplicative across some of those spokes, you can come then to your 26F conference. Again, it's just doing your homework as you would before arguing any motion or going into any deposition. This is as much a piece of advocacy as it is case management. So you got to be able then to understand your data map. What do I know and what don't I know? Because that will help you make targeted concessions or agreements with the opposing counsel. I found in many construction cases, there's not so much an information asymmetry as far as the drawings, the change orders, the contracts. Those have already all been exchanged. Where it really exists is in some of these ancillary data sources, such as the messaging, the text messages, you're not going to say something over email anymore, but man, I can't believe we messed that up in a text message or a Teams chat. That may be helpful. So again, you don't have to know every relevant document going in, but if you have a chance to do some iterative search, some practice search terms on the data, or what formats may be less costly. Does it make sense to phase discovery? Maybe we do discovery of, think about a loss of productivity claim. Maybe we're looking at accounting records for this project and then expanding it to a broader portion of the database. Do you want to set deadlines for interim productions and final productions to give everybody a chance to review a certain data set before then moving on to the next data set? And understanding where your information gaps are and focusing on opposing counsel or third parties. So by understanding all this going in, the key really is size, location, and cost. If you can explain those three things, and a lot of times, in the more complex cases, it's helpful to have someone like Julian there who can explain it and really understand the data to frame a good discovery plan for the court before your scheduling order is entered. So with that, we'll open it up to questions if there are any.
Looking at the chat, it doesn't look like anybody's dropped anything into the chat, but if you have questions, please feel free to drop them in. Yes, Katie asked if we can get access to the PowerPoint presentation. The answer is yes. We'll make sure it's converted to a PDF and then sent over through Kanita.
Yes. One question I had is, we discussed metadata. Are you able to, or is it ethically allowed to scrub that metadata? Are you considering that and determining how you would like to turn over production to opposing counsel?
It's a great question. I guess the biggest answer to that is, how important is the metadata? Does it contain personal information that is identifiable and therefore needs to be scrubbed, or does it not? There is obviously, if the metadata has a direct impact on the case. So for example, if I'm dealing with a case where the date of a change order is important, and on the face of the document, the date says one thing, but that doesn't seem to align with other fact discovery, then the metadata of that document may be very important. Oftentimes with an ESI protocol or during a Rule 26F, you can discuss how you're going to exchange your information. Many state level cases just exchanges PDF where the metadata is not necessarily as important, but have the ability to go back to the metadata if and when a question comes up. In other more sophisticated cases or with more sophisticated clients, you may actually have an ESI protocol that governs the production in a specific format, not just PDF, but extracted text, a TIFF or an image version that's bait stamped, as well as a metadata for each document in the load file. So in the words of an attorney, the answer is it depends, but I think it really comes down to making sure you still have access to it, because there are times when the metadata is going to be important, even when you're not producing it right away.
I echo what Julian says, and I also would say counsel have to be careful about potentially privileged information and metadata. That is, was an email sent to counsel? What is their advice in it? So metadata presents a unique set of challenges as well. And I think that's part of the reason that 26F conferences involve not only considerations of what metadata will be produced for what types of files, and also what type of clawback agreement do you want in place in case you inadvertently produce something, because with terabytes of data in certain cases, it's not going to be possible to get eyes on every spec. So clawbacks become very important in that respect as well.
Absolutely.
Well, it looks like we're out of time, though. I'm sure there might have been some more questions people might want to ask. This was a really interesting presentation. I do see one more question. I'll go ahead and ask it. Anyone who wants to log off can. Are you finding that courts are requiring construction companies to provide their job cost accounting and labor data, as it could be relevant for determining damages based on actual costs?
So I think it depends on the amount in issue and the adequacy of other records. That is, if I'm asserting loss of productivity over a 2-year period on a multiple $1 million infrastructure project, I probably, and I don't have a good measured mile, then I probably need to come with some backup data, whether that's a comparative project, or whether that is just for that my estimate was accurate, some basis to say that the cost data as bid versus my actual experience is different, and that the cost data are reliable. So I think it depends on the size of the case. If you've got good day-to-day job records, then that's one thing. But again, the 26A1 mandatory disclosures require you to produce documents that are material and relevant to support your calculation of damages. So if you used it to calculate your damages, then it's probably within the scope of 26A1 already. So whether courts are requiring that as a matter of proof versus, just production, again, I think that's something that you can talk with opposing counsel about and say, do you really want the entire database? Because if so, we can have that conversation. And just because you have a conference and have to submit a report to the court doesn't mean you have to agree, but at least understand the costs and scope of what each side is asking for, and then argue to the court, say, Your Honor, let's look at labor records for this division of the company for this period, and then if we need to go farther, we can come back and discuss that. So I think the 26F conference helps you frame those issues and avoid that problem down the road, or at least understand if it's going to have to be done at the outset.
All right, I do think we have to wrap up. Excellent presentation. And we'll make sure that the actual PowerPoint gets shared with anyone who wants it. Okay. Okay.
Thank you, everybody.
Thanks, everyone.
Bye.